Welcome to our YouTube video series on employment law. My name is Christopher Neufeld of Neufeld Legal, and in this particular video, we will be discussing potential problems associated with stat pay as it appears on employee payroll statements. Stat pay can be a highly problematic aspect of employee payroll, given the potential for it being improperly applied and calculated based upon the jurisdiction in which the employee is working. This is evident from the choice of terminology, in that the abbreviation purportedly stands for statutory holiday pay. Nevertheless, there is only a single province of Canada that uses statutory holiday pay in its employment standards legislation, being the province of British Columbia. Meanwhile, in the United States of America, most states do not impose holiday pay through legislation, such that the concept of statutory holiday pay is largely foreign to employees in the United States of America. If we look at employment standards legislation across Canada, we see that the term public holiday pay is used in the provinces of Ontario, Saskatchewan, and New Brunswick. The term general holiday pay is used in the provinces of Alberta and Nova Scotia. The term paid holidays is used in the province of Prince Edward Island. And the term holiday pay is used in Manitoba, Newfoundland and Labrador, and pursuant to the Canada Labour Code. It is only in the province of British Columbia that we see the term statutory holiday pay being used in the province's employment standards legislation. The province of Quebec does refer to statutory general holidays. However, the payment due to employees is known as an indemnity, with no reference to the term stat pay or statutory holiday pay. Thus, we begin to observe the beginnings of the problems associated with stat pay, in that it would appear to have its basis in but a single province, and no significant effort was made to correlate it to the specific legislative terminology of the province within which the employee was working. And when one fails to modify something as simple as terminology to meet legislative prerequisites, it is easy to understand how calculations can also be inconsistent with the specific computational methodology of the province. For each province has its own computational methodology for calculating its own form of holiday pay, with the variances sometimes being slight, but other times being quite significant. However, should the effort not have been shown to modify the terminology to meet provincial specifications, can one really expect the math to have been modified to meet provincial specifications? It may have been modified, although in our professional experience, this is quite infrequent, and therefore demands investigation to ascertain whether or not the math is correct, and thereupon determine whether or not there is earned money that is owed to the particular employee. By way of example, the computation of general holiday pay and general holiday pay while working in the province of Alberta can be a very extensive mathematical formula with many variables needing to be added in. The reason for including so many variables is that general holiday pay in Alberta is not based on one's regular hourly pay or salary, but upon one's wages, and where the employee worked on the holiday, also upon an overtime rate derived from the employee's wage rate, which is a product of the employee's wages. And when you get into the component parts of wages, as established by Alberta case law, the mathematical formulas can be quite extensive, even though they are relatively straightforward. The problem, however, is that it makes general holiday pay that much more expensive for employers, such that they all too often stay with the simplified approach, even though it is inconsistent with the Alberta Employment Standards Code. The issue for salaried employees in Alberta can be even more significant, given that general holiday pay might not be reported on the employee's pay statement and therefore not paid. Or alternatively, general holiday pay may be listed on the pay statement, yet there is a corresponding deduction from salary that is inconsistent with the Alberta Employment Standards Code and prevailing Alberta case law. As such, the problems associated with stat pay can be quite significant, and we are only scratching the surface with this particular video. To properly understand where you stand in relation to what you are owed, your pay and pay statement needs to be reviewed against the employment standards legislation that sets out the employer's reporting and payment obligations, reflecting the significance of analyzing stat pay as it appears in an employee's pay statement. Thank you.